Welcome to This Week in Education Law, School Administrator's Guide, episode number 20. Today I'll introduce a case about whether a teacher could bring a Make America Great Again hat to teacher-only trainings. In this case, Eric Dodge was a 6th grade science teacher at Evergreen School District number 114 in the state of Washington. The week before the 2019 to 2020 school year started, the teacher attended a cultural sensitivity and racial bias training held at his school building. About 60 people attended the training, which was presented by a professor from Washington State University. The teacher wore his MAGA hat up to the front doors of the school building. He then took it off when he entered the building. During the training, the teacher sat near the back of the room and placed his hat either on the table in front of him or on the top of his backpack. He did not wear his hat during the training. The professor who provided the training saw the teacher's hat. After the training, the professor complained to the school principal that she felt intimidated and traumatized. A few teachers who attended the training also told the school principal that they were upset by the MAGA hat. One teacher cried, and another teacher found the hat threatening. There was no allegation that the teacher did anything with his hat during the training other than place it near him with his other things. Nor was there any allegation that he did anything to interfere with or disrupt the training. The school principal called the district's chief human resource officer to discuss what could be done, and they agreed that the best option was to talk to the teacher directly, explain the reaction that the MAGA hat had elicited, and give the teacher a heads up that he was most likely inadvertently causing distress, and give the teacher an opportunity to respond to that. Later that afternoon, the school principal spoke to the teacher in his classroom. The principal asked the teacher why he wore the hat. The teacher explained that he wore the hat to protect the sunspots on his head. He also explained that he liked the message behind the hat because it spoke to everybody by saying, let's all do it the best we can and be the best we can at whatever it is that we do. The principal responded that some people took the hat as a symbol of hate and bigotry. While she could not ask the teacher to stop wearing it, the teacher should use better judgment in the future. The teacher tried to explain that he wore the hat to show that maybe they were not all bad. The principal stated that the teacher denied trying to engender some kind of response with the hat by bringing it to a racial equity training. The principal also stated that the teacher attempted to talk politics during their conversation, but that she shut it down. The next day, the teacher attended another teacher training that was held at a high school. The teacher again wore his MAGA hat before entering the building and then took it off while he was inside. Another teacher who was present at the first day's training saw the MAGA hat and texted the principal. The principal again called the same HR officer, and they agreed that the principal needed to set a clear directive with the teacher to not have the hat in the training where it was causing the disruption to staff. When the training at the high school was over, the teacher drove back to his own school building for a third training held on the same day. This time, the teacher left his MAGA hat in his truck and did not bring it to the school building. When the training was over, the teacher stayed behind to talk to the principal about teaching classes other than science. Recollection varied on what happened during this conversation. The teacher alleged that the principal called him a homophobe, a racist, and a bigot, and hateful. The principal also stated, "What's the F deal with your hat?" When the teacher denied wearing his hat at his own school building on the second day, the principal called him a liar and specified that She did not want him wearing the hat, period. Finally, the principal said, "Next time I see you with that hat, you need to have your union rep. Bring your rep because I'll have mine." But the principal disputed that she mistreated the teacher, including by using profanity or raising her voice, but she admitted that she was frustrated and viewed the teacher's continuing to have his hat with him as insubordination. Later that night, the teacher emailed his principal, stating that he was taken back by their conversation that day and her unprovoked attack made him sick to his stomach and nervous. The teacher also stated in the email that he was sorry for offending her. The school principal responded 2 days later, recounting that he admitted to wearing the hat to purposely provoke a reaction or response from his colleagues. The principal explained that her reference to union representation only meant that if we needed to discuss the MAGA hat again, I would have another administrator with me to take notes, and you would be invited to bring a representative. The principal forwarded the teacher's email and her response to the HR officer, who praised it as an excellent response. The teacher then contacted his union representative, who contacted the school district. After being informed that the school district would not take any action against the school principal, the teacher filed a harassment, intimidation, and bullying complaint against the principal through the school district's online reporting system. The teacher also requested a transfer to a different school. The teacher's harassment, intimidation, and bullying complaint was sent to the same HR officer who praised the school principal's response as excellent. The HR officer initiated an investigation and contracted a third-party liability investigator to perform the investigation and determine whether the principal violated the school district policies in her treatment of the teacher. During the investigation, the HR officer received a public records request from the local news agency related to the teacher's harassment, intimidation, and bullying complaint. The HR officer told the teacher, in her response to the public records request, she may disclose information from the teacher personnel file. But if the teacher withdrew his complaint, then she would not have to disclose the information. The teacher declined to withdraw his complaint. The third-party liability investigator's preliminary investigative report concluded that the teacher was singled out because he wore a MAGA hat and was subjected to negative treatment and denied his freedom of expression because of perceived stereotypes or political differences of opinion. The preliminary report also found that the teacher had not violated any school policy by having his MAGA hat, that the school principal had allowed other types of political messaging around the school, and that her reference to union representation was reasonably perceived by the teacher as a threat of discipline. The same report also determined that the school principal had not technically violated any school policy because the school district's anti-discrimination policy did not ban discrimination based on political beliefs, and the encounters between the teacher and the principal did not rise to the level of harassment, intimidation, or bullying. The HR officer asked the third-party liability investigator to change some of the language before issuing its final report. The HR officer was concerned that the investigator's conclusion about violation of the teacher's freedom of expression and him being singled out for his political beliefs were outside the scope of investigation task, which was to investigate whether the principal had violated the school district policy. The investigator removed the language that the HR officer had concerns about. With the final report of the investigation, the HR officer determined that no policy violation had occurred and wrote a letter to the teacher explaining that no further action would be taken on his harassment, intimidation, or bullying complaint. The teacher appealed the HR officer's denial of his complaint to the school board, and the school board affirmed. However, the school board ordered further investigation into whether the principal had acted professionally in her interactions with the teacher after the board became aware of parents' complaints about the school principal. During this second investigation, the school board informed the school principal that the board had a strong belief that her conversations with the teacher were not as she had represented, in addition to concerns about her professionalism, which bring credibility into question. The school board gave the principal the choice of resigning as a principal and accepting a demotion or facing disciplinary proceedings. The principal resigned at the end of the school year. The teacher sued the school district, claiming, among others, that the school principal retaliated against him for having his MAGA hat, in violation of his First Amendment right to free speech. The district court concluded that the principal and the HR officer were protected by qualified immunity because it was not clearly established that their actions violated the Constitution. The teacher appealed. The Ninth Circuit concluded that the teacher was engaged in speech protected by the First Amendment because his MAGA hat conveyed a message of public concern, and he was acting as a private citizen in expressing that message. The two key issues here are, first, addressing matters of public concern, and second, speaking as a private citizen. What speech is considered addressing matters of public concern? Its definition is broad. Speech addresses an issue of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest. The speech addressing the policies of the president's administration is a matter of concern. In this case, the principal and other teachers viewed the teacher's MAGA hat as a comment on issues such as immigration, racism, bigotry, which were all matters of public concern. The second issue is whether the teacher was speaking as a private citizen. This depends on the scope and content of the teacher's job responsibilities. A person speaks in a personal capacity if he had no official duty to make the questioned statement, or if the speech was not the product of performing the task he was paid to perform. In this case, the teacher had no official duty to wear the MAGA hat. It was not required to perform his job, nor did the teacher wear the hat in school with the students. If the teacher wears the MAGA hat in schools with the students and parents, then it could be considered that the teacher is speaking as a public employee, not as a private citizen. This is because the teacher is performing his official duty and he is taking advantage of his position to press his particular views on impressionable and captive minds before him. But in this case, the teacher brought a MAGA hat to teacher-only trainings. Although some attendees may have been outraged or offended by the teacher's political expression, there was no evidence suggesting actual or tangible disruption to school operations. Some teachers may not like the political message, but dislike cannot itself be a basis for finding disruption that outweighs the speaker's First Amendment rights. The principal clearly violated the teacher's right to free speech. It is important to point out that a government employer, a school district included, can categorically prohibit political speech as a valid administrative interest as long as the prohibition does not favor or disfavor any particular view. In this case, the school district adopted a policy prohibiting all political messaging in school after the teacher filed his complaint. It means that when the teacher brought his MAGA hat to the training, the teacher did not violate the district policy because the policy was adopted only after he filed the complaint. The court also noted that the principal openly admitted and defended her allowance of other political symbols and speech at her school, including a Black Lives Matter poster hanging in the school library and a Bernie Sanders bumper sticker displayed on her own car. And this speech was not without its own controversies. When another teacher, married to a police officer, expressed concerns about a Black Lives Matter poster directly to the principal, she took no action. The principal testified that she could not understand why the teacher felt the Black Lives Matter poster was disrespectful of police. The court reasoned that the principal's different reactions reflect her viewpoint preference. A reasonable school administrator at the time of the events in this case would have known that this was improper and the perceived unpopularity of a political view is not itself justification to prohibit protected expression. As for the teacher's retaliation claim, the circuit court reasoned that the school principal had authority over the teacher's employment. The principal made the statement that the next time the teacher had his MAGA hat, they would have a meeting in which he would need his union representative. At a minimum, the teacher could reasonably interpret the principal's statement as a threat against his employment. The principal also had her First Amendment rights, but she cannot use her position of authority over the teacher as a means to retaliate for her subordinate's speech.